Hi everyone, this is Posh from the Beautiful Brand, and this is Module 6, and we'll be discussing trademarks and protecting your brand. So the best time to protect your brand is when you come up with your company name. This is because the name that you're going to choose ultimately will probably will become your main or primary brand name. So when you think about your brand expanding or getting acquired one day, you'll have a lot less headaches down the road. The other thing this module is going to go over is the fee schedule. The fee schedule of trademarking is not just the 10 years like everybody's led to believe. You register your trademark and you believe that it's, safe and protected for 10 years and that you have to do nothing else, but that's not true. There are steps you have to take. There are other fees you have to pay before the 10 years is up. And in this module, I am going to go over just how you do that, and it should be easy peasy lemon squeezy by the time I'm done explaining it to you in slides and examples. So, watch, listen, and learn. That's it.
Trademarks are important to your brand, and trademarks can be a confusing and intimidating subject to approach in itself. But it's actually very simple to understand if explained easily, which I'm going to try to do. So whether or not to secure your trademark is solely your decision, but I would make sure that you're sure before doing so, as it can be a risky investment. The reason I say risky is because if you're someone who changes careers or business ideas often, I don't usually recommend purchasing trademarks, but again, that is a decision you have to make on your own. The other reason is that if you don't do your homework, you could have your trademark suspended or rejected for multiple reasons, and the fee that you pay to the patent and trademark office is usually non-refundable. So here's where this all gets interesting, and a lot of people don't know this, but you can legally use the trademark symbol after your brand's name or logo, even if you aren't registered yet. Okay? Of course, however, you have no legal protection when doing this. The only purpose this serves is to deter someone that is contemplating using a word, name, or mark that you have been using for a while now, not to use it because they don't know if it's actually registered or not until they have a trademark search done. So it implies to the individual that maybe it is and maybe it isn't registered legally. However, you absolutely 100% cannot put the registered trademark symbol after your company or product name. This is illegal and could come with fines if you choose to break this law. So again, if your trademark has not officially been registered with the U.S. Patent and Trademark Office, you cannot use the registered symbol after your logo or name. You can only use the trademark symbol. If you're someone that's highly and seriously vested in your business and brand, and you see absolute long-term growth with it, I highly recommend registering a trademark. Otherwise, what's to stop someone else from using your exact name on a similar company or product you have, and then they register theirs first because you dropped the ball? I would hate to see this happen, but the reality is that it happens all the time. So when people don't educate themselves on the benefits of trademarks or how to go about filing one, it can get messy. So you have to really make sure that it's something you want to do and invest in. But with all that being said, if you didn't know much about trademarks and how they work, I'm assuming you are gaining this knowledge right now. Some people will still want to save money and take the risk of not getting a trademark for a business they plan on being vested in. And now I want to talk to you a little bit about foreign countries and your trademark. If your trademark isn't registered in another country and only the United States, someone from that country can utilize your trademark in their country. Get it trademarked in their country and they will not be affected by your U.S. trademark. This sucks, I know, but it is the way it works. However, what then happens to the company that trademarked your name in their country? If they have products that they want to sell in the US, it most likely will not happen because you can file your trademark with the US Customs to stop infringing foreign products from entering the US. Technically speaking, you should register your trademark in any country or jurisdiction where you offer your products or services under your mark. This is tricky, but becoming more common to do with all the online stores and boutiques around the world. A lot of people ask me, how long do trademarks last and do they even expire? A lot of people don't know that trademarks, in fact, do expire, and there are several filing processes you have to do before even the 10th year. So by law, they expire after 10 years unless you file an application for renewal between the 9th year and before the end of the 10th year following the date that your trademark was registered. Provided there are no issues or problems, your trademark will be approved for renewal for another 10 years. But before you can even do that, there are prior steps, which I have broken down for you. And you don't want to overlook this, so I'm going to go over it. So say you registered your trademark on May 10th of 2010. You need to do a first 5-year filing on your trademark between May 10th, 2015 and May 10th, 2016. Your second filing will be the 10th year filing. So you would need to register for your 10th year between the dates of May 10th, 2019 and May 10th, 2020. After that, it continues to be every 10 years. You won't have to do another 5-year filing. It's just every 10 years after that. For the 5-year filing, the document you'll need is called the Section 8 Declaration of Use. And that means that you certify that you're still continuing the use of the mark within the category you specified and must include a specimen. And a specimen is basically either one of your labels or a product or an advertisement of your service, and this also has a filing fee. And usually they ask for pictures of these things, of your labels, your product. That's all. You don't have to actually really send it in. And the 10-year filing document you'll need is a combination of the Section 8 and 9 document, which obviously includes the Section 8 declaration. The Section 9 which is a request for renewal of registration. It also has a filing fee. Everything has a filing fee. Please know that these are mandatory filings and they are required in order to keep your registration alive and well. Failure to do any of these filings after your initial and original application will result in the cancellation of your trademark. So don't go in blind on this and don't overlook this important info, because I know a few major beauty lines whose trademark is considered expired and abandoned because they did no filings at all. And one of them currently actually has products in Ulta stores. So don't let this happen to you. I'm not even sure how that works. This is how your business is broken down when filing for a trademark at the U.S. Patent and Trademark Office. Your business or service category has to be in range of a certain class and deemed acceptable by the USPTO, which is the United States Patent and Trademark Office. Otherwise, your trademark application may be denied. I suggest you get help from a trademark attorney, paralegal, or someone who's gone through the process if you don't feel comfortable doing this on your own. The trademark classifications are a way that trademark examiners have to arrange and file documents according to the description and types of goods and services to which the marks apply. There are dozens and dozens of class categories, and it is important not to get your class wrong, because if you end up filing in the wrong class, you will lose your application fee. Don't let that happen. So I'm going to give you a scenario, so maybe it's a easier way to understand classifications and categories. So say you have a jewelry company named X, Y, and Z. That's what we'll call it, X, Y, and Z. And you want to trademark the name. You've had a trademark search performed, and find out that there is a company with the same name. The company with the same name sells chocolates, however, and other edible sweets. The good news is you both will probably register the name and get it. And the reason being is because you both are in two completely different class categories. The trademark office looks at these things when deciding on whether or not they can issue a trademark. But where things like this can get difficult and backfire for you is when you decide to trademark an extremely popular name brand on a completely separate class or category. You may be legally entitled to do it, but, why rock the boat? I don't know. Some people, I don't know. I wouldn't do it if I were you. So, with that being said, I'll give you another scenario if you did want to do that. So say you want to trademark the name Smashbox for your clothing line. You are now seriously pushing the limits on this because Smashbox, if some of you don't know, is an insanely popular cosmetics brand and they may or may not have wanted to dive into clothing, or they may already have their name on t-shirts. Who knows? Well, now, so what you did, you just completely mess with them going into that category. And now you take the risk of kind of messing with a very popular brand with a loyal following around the world, and you could potentially lose your application fee if you did not do your homework on their categories. I know this is pushing it with scenarios, but you get the general idea. It's a little tricky. As far as infringement issues, if you do nothing else, please make sure to search names before you pick one. Do yourself and another potential owner a favor and research names to be respectful, and make sure someone else is not already using the name you want or choose. If you come across a name you really want badly and you find that someone is using that name, don't just assume that they have no trademark protection on it, because it becomes a hassle for both parties involved. Besides, wouldn't you want your own unique identity to brand with? I have seen many times and also have experienced myself where trademarked brands have had to track down people that were infringing on their trademark. This is something you must do on your own unless you can afford an attorney to do it for you. You literally need to do your due diligence and be mindful of violating anyone's brand, because you wouldn't want it to happen to you, and it's no fun, trust me. It's annoying and it's time consuming. And with that being said, I'm going to give you a scenario in that case. So you've come up with a great name for your new business and you love it. There's no way no one has this unique name you've thought of. You did a search online by putting the name in Google. You see a few things similar, but not exactly. So you decide that this is the one for you. It has now been a year. You haven't gotten around to trademarking the name yet legally. And you've labeled your products with your name, put social media pages up, you're getting a good following, and everything is taking off great. Then you come to work one day and check your emails, only to have an email from an attorney that is claiming that you are infringing on his client's trademark and has now issued you a cease and desist notice. A cease and desist notice means that you can no longer continue to use the name that you have picked, effective immediately usually. If you refuse and ignore the notice, you will face legal actions, but they usually give you like a 7 to 14 day time frame to respond to the notice, and sometimes longer depending on each situation. But if you choose to ignore this message or not resolve it, yes, they can take legal action against you. Okay, so with that scenario, you're panicked about this, okay? Because you got the cease and desist, and all you see all your hard work going up in flames along with dollar signs right now. So you call your attorney or an attorney, and they tell you one of two things. They'll tell you one of these two things. One, you should have had a thorough trademark search done because they own the name outright and they also sell the same type of products that you do. You cannot use it, he says, and you'll need to start over, unfortunately. Or he'll say, Oh, don't worry, you're okay. There was a bit of confusion, but you both would be considered to be in two completely separate categories, and it isn't an issue. However, you're going to need to trademark your business name under this specific category. So this leads me to state again, protect your trademark if you currently have one. Become the trademark police and protect and serve.